To know and understand the rules of the game, here's two vital things for you to keep in mind. One, what it doesn't say can be more eloquent than what it does say. Remember? If you're reading along and it doesn't say empty trucks have to enter, there's your loophole. Empty trucks are excluded because empty trucks are not listed in this statute. Okay? Then the other side of the coin is, if there are exceptions then, they've got to prove that you're not one of the exceptions. Here's an example. In our driver's license law here in the state, the prima facie case against a person who doesn't have a driver's license is in Idaho Code, I believe it's 49, 319, or 17 along in there. And where it says, persons who have driver's licenses, or all persons who have a driver's license shall, upon demand of a peace officer, display said document upon demand. And the key words are, all persons who have driver's licenses. But, Your Honor, this prima facie case fails. The state has failed to show that I'm a person with a driver's license. That wins. You bet. You see, the prosecutor has got to prove that I am a person who has a driver's license and failed to show it. There's another loophole to keep in mind on this driver's license. There are 5 separate categories of persons who are excluded from having a driver's license. 2 of the 5 are, if you're in the military service, you don't have to have a driver's license. And if you come from a country that does not issue driver's licenses and you're in the United States, you don't have to have a driver's license. Well, who's to say I'm not from Qatar or South Africa or Bahrain or North Yemen? And I don't know whether they've got driver's licenses or not, but the burden of proof on the prosecutor is this. He's got to show that you are a resident of the state of Idaho, that you're a citizen of the United States. 99 times out of 100, they never waste time trying to prove little nitpicky things like that. And so at the prima facie break then, in other words, when the state rests, Your Honor, I move at this time to exclude the jury. I have a motion for the court. Well, I move now, when the jury's out, for dismissal for failure of the state's prima facie case. The state has failed to prove that I'm a citizen and a resident of the state of Idaho and that I'm not from North Yemen, which is specifically excluded under the terms and conditions of this particular statute, and then you have to cite the statute. And the judge will determine whether or not they've covered that ground. Now, I'll concede that those are kind of Mickey Mouse compared to this thing called the grand jury. But there's just a couple of more examples of technical moves that you make pursuant to the rules, that if they fail to prove their case, you move for dismissal. And you can only know about that by reading the rules and reading the specific words that are involved in the rules. Now let's get back to this judge. I won't mention his name. He's a nice fellow. In fact, one time, I've got to tell you this story about this particular judge because he's kind of like a chameleon. He changes his color from time to time, and this may happen to you. So let me just tell you this little quirk of law and how I won a particular case with this same judge who, when I brought up the subject of the information and the grand jury, just came uncorked. Now this particular judge, we'll call him Schmidley just for the sake of the name, was sitting in court, and I'd been summoned in by the Department of Employment. And they wanted certain records and documents and books from me, and at that time I was running a corporation. And this corporation was duly licensed in the state of Idaho, and it was operating in intrastate commerce and interstate commerce all over the West. And in those days, I didn't know the difference between a corporation and an individual because I'd never read Hale versus Hinkle. And I didn't understand the law very well. And I thought I had rights. And so what they really wanted was the names and addresses of the subcontractors who worked for the company so that they could go harass them. There was a number of people who were operating under contract who were not employees. And I knew what they were after. And so we got pretty crafty at this, and we wouldn't tell them who these subcontractors were because I was barely able to go into the courtroom myself and argue and present my own position, much less other people who were less knowledgeable than I was, and I was just plain stupid. So if I was stupid and they had less knowledge than I did, they were really in a bad way. So to protect them, we just kept their names away, and they wanted this information. So they served me with a thing called a subpoena ducis tecum. And with this subpoena, they're sitting there saying, we want you to bring forth all these documents and evidence. Now remember, Hill versus Hinkle says that the corporation cannot resist the suit of the state, but the individual can. Well, not knowing that, I just went ahead and resisted the suit of the state like I was an individual. And so they had brought me before this district court judge. And this district court judge is sitting up there on the bench in all of his pompous grandeur. He'd seen all of the motions and briefs, and this was an order to show cause hearing. And an order to show cause as to why I should not deliver these 7 items that they wanted. They wanted all of the contracts that the company had written with anybody. That would be suppliers, customers, employees, subcontractors, anything like that. In addition to our normal check registers and book journals and things like that. And there were 7 of these particular items, and of course, I wasn't the company's controller, so I was really pretty ignorant about the day-to-day operation of the money and contracts as it relates to accounting and bookkeeping, because I'm not trained in accounting and bookkeeping. And so you usually have what's called a company controller, and he takes care of those things, and he separates out the books, and he can tell you, for instance, how much hardware do we use per month. And he'd separate that out and say it's $3,644 worth of hinges, $2,011 worth of magnetic catches, or whatever that is. That's part of his job. And he knows all the contracts, and he knows all the payroll journals and all the tax matters. And so the particular fellow that I had working for me was a Jewish fellow, and he was an old-timey New Yorker, and he kept the payroll, he kept all of the company's business in what's called a journal. And this journal was kept in code. Now, remember, the law says that you have to keep records and books. The law doesn't say you have to keep records and books in English. Getting the pitch here? Not only didn't those of us at the company know and understand what was happening, anybody who got hold of the records and books couldn't figure out what was happening either. Now remember, we're trying to keep the records and books away from the government. So we got into court, and I jumped up and down, and I ranted and raved and pawed the ground and bit the bushes, and boy, I'm just out here quoting law and Supreme Court cases and the whole 9 yards, see? About 15 minutes into my presentation, the judge says, "Excuse me, Mr. Gordon, I'm sorry to interrupt. May I ask you a question?" "Yes, Judge." "Is this company a corporation?" "Yes, Judge, it is." "Okay. I'm sorry to have interrupted, Mr. Gordon. Go ahead with your presentation." He's just up there taking notes, And this goes on. About another 10 minutes later, he says, "Excuse me, Mr. Gordon, may I interrupt again?" "Well, certainly, Judge. What do you want to know?" He said, "Mr. Gordon, are you the president of this corporation?" "Yes, I am, Judge." "Oh, okay, Mr. Gordon, go ahead." And he's up here writing notes again. This goes on for a little while longer, and he said, "Excuse me again, Mr. Gordon. I'm sorry to continually interrupt, but as your presentation goes on, it's necessary that I keep abreast of what's happening here, and so I can make a judicial determination. Mr. Gordon, is this corporation an Idaho corporation?" "Yes, it is. Chartered right here in the state of Idaho." "Okay, Mr. Gordon, go ahead." And a little while later, "Excuse me again, Mr. Gordon. May I ask you another question? Is this Idaho corporation of which you're the president engaged in intrastate commerce?" "Yes." "Is it engaged in interstate commerce?" "Yes." And he keeps writing this down. Go ahead, Mr. Gordon. And I went on and I ranted and raved and jumped up and down and pawed the ground and bit the bushes some more. And pretty soon I got through. And the state's attorney got up and she quoted some case law. And she made her presentation. And the judge said, well, thank you, Mr. Gordon. That was a wonderful presentation. And this was a lady lawyer, and he said, Mrs. Jones, you've just done a wonderful job in this presentation, and I really appreciate all the input and all the information and all the legal authorities and all these legal sites. Just as you just couldn't ask for a better judge. Had his neutral hat on, he just sitting there watching the ball go back and forth and calling the shots as they hit the net. And 21 days later, we got his answer. He didn't demand that we deliver all 7 items. You see, we had agreed to deliver 3 of the 7 items. We didn't have anything to hide, and we had paid all of our taxes, and we could prove that, and so we were prepared to give him the checkbook journal and payroll journal and the tax returns and things like that. What we didn't want to give them were the contracts and various and sundry other things that we, just felt that wasn't any of their business, what we really wanted to protect. And I got the answer back, and I don't have it right in front of me. This happened 3 or 4 years ago, but the order said something like this. Mr. Gordon does not have to bring in, or the company does not have to bring in the following documents. That is, contracts with its suppliers, contracts with its customers, contracts with its subcontractors. But the judge says, you shall then and there, now here comes your 3 items, produce for inspection the following items. All checks, checkbook, register, and journal, and etc., and it had this stuff down there. So I went to my friend, who's an attorney, and I said, well, looks like we got a half win and a half loss. We were successful in keeping them from getting the contracts, which is what they're really after, but we have to give them these 4 items here, or these 3 items. And he said, no, George, your problem is that you can't read. But wait a minute. It says right here, you shall then and there produce for inspection in the office of Joe Simoli at 9 a.m. on November the 4th the following information. And he said, yeah, that's right. I see what that says. Well, then I have to give them that information, and they're going to audit it. And my friend said, George, read the order again. And I read it again, and I said, it says very plainly there, Ben, you shall then and there produce in the office of this accountant at the Department of Labor on the 4th day of November, 1979. And I have to do that, it looks like to me. And he said, where does it say in that order that you have to leave those records in that office? And I read it again. And sure enough, the word leave the records in the office wasn't in the order. It said, you will then and there produce for inspection the following documents in the office of Joe Simoli at the hour of 9 a.m. on the 4th day of November, 1979. So, here's what I did. Of the 3 or 4 items that I had to produce, I put them in a suitcase, and there was quite a bit of information. And I took them to the office, and I set them down on the table. And there was only one person in the room, and I took with me 2 witnesses. And here's my 2 witnesses here. And there was only one person, and this accountant looked up and said, oh, Mr. Gordon, you've brought the records. And I said, yes, I have. I have obeyed the court order. Now, would you bring in a couple of witnesses so that we could make sure that there's no misunderstanding and that you don't say later that I'm in contempt of court or that I haven't obeyed this court order? And so he called in a couple of other guys, and now there's 3 of them and 3 of us, and there's 6 of us, and we're gathered around the table. And I said, now let me read to you the court order so that we all understand what the subject matter is. it says in the court order that you will, then and there, in the office of Joe Schmidley. Is this the office of Joe Schmidley? And everybody nodded yes. Okay. So I've obeyed that portion of this court order, haven't I? Yes. At the hour of 9 o'clock. And I looked at my watch and I said, I'm sorry, it's 5 after 9, and so will you forgive me for being 5 minutes late? And everybody said yes, there's no problem, 5 minutes late. Okay. And you will then and there produce the following documents. And I said, now, is this the time and place set certain? Yes. And is this the 4th of November? Yes. And is this 1979? Yes. See, everybody's agreeing. Okay. Just reading the court order, exactly what it says. All right. And it says that I shall produce for your inspection in this office. Is that correct? Yeah. Okay. Now, I opened it up and I said, time cards. Do you see time cards in that suitcase? Yes. Checkbook disbursement journal. And I pulled it out and I said, do you see a checkbook disbursement journal? Yes. And all canceled checks for the year 1978 or 9, whatever it was. And do you see canceled checks? Yes. Now get a Fourth Amendment warrant and I'll leave them. And I picked up the suitcase and my friends and I walked out the door and everybody was just absolutely aghast. See what happened there? I did just exactly what the court order said to do. Now, any rational, normal, everyday garden variety citizen would assume that the judge intended and meant for me to leave them there so that they could be audited. But, my friends, that is not what the order said. And in law, what it says is what we do. What it doesn't say, we don't do. And we don't make assumptions and guesses, and we think that it probably, and my common sense tells me that I should do this or that. If you don't think they just came unglued. They jumped up and down. You think I was pawing the ground and biting the bushes. They had me back in court in about 3 weeks, I guess. Now I went into this very same judge. Mr. Gordon, you've been called in here in order to show cause as to why I shouldn't hold you in contempt of court for not following my instructions of the 4th day of November 1979. Mr. Gordon, will you please tell me why I shouldn't hold you in contempt of court? And this judge is sitting up there. I could just tell. He was all he could do to keep from laughing, see? And so I said, well, Your Honor, you shouldn't hold me in contempt of court because I obeyed the court order to the letter. I did everything that court order said, and I recited back to him what had happened, see? And he had to cover his mouth like this. He didn't laugh. It's not his job to laugh and make sport, but, you know, I just told him exactly what I just told you, and I'm just doing exactly what the court ordered. And, Your Honor, I have 2 witnesses who were right here, right there in that office, and they're going to testify to the same thing. And so the judge looks over, and this lady got up, and she said, well, common sense and intelligence and reason and rhetoric, and she just waxed eloquent there for a long time. Pretty soon the judge says, well, I'll give you my opinion. And so about 3 weeks later, I got his opinion again, see? Now, by this time, we've had a lot of time to solve any bookkeeping entries or problems. I think the judge probably thought that we had some entries that we needed to change in our bookkeeping, and he was going to give us plenty of time to do that. Actually, we didn't need to do any of that. Everything was legal and lawful and right up to the moment, and we'd actually already solved our problem. We just didn't want to show him any contracts. And so he issued his order. He said, pursuant to the statutes, the corporation shall deliver and leave in the office of Joe Schmidley. See, now he changed his order to read, you shall leave them there for an inspection. So we took them in. Now here's the kicker. Remember my Jewish friend who was the company controller? You just remember this, whatever business you're running, or whatever your private life is all about, because this is the most valuable bit of information that you can get as a businessman who's going to be dealing with the bureaucracy. You have to keep records in your corporate capacity, but you don't have to keep them in English. So I took all this stuff in, and we were all kind of laughing and scratching, and we thought we'd had a good time, and they'd probably spent $2,000-3,000 on litigation, and it took them a year to get these documents, and after a year they finally got them. And I think we were starting to learn that corporations couldn't resist the suit of the state. I think about now I was starting to learn something about the law. I got a call on the telephone, and on the telephone it says, we need the code. That was the first word that I'd ever had of the word code in my office, and I'd been there for 4 years. And I said, code? What code are you talking about? This checkbook disbursement journal is written in code, and we have to have the code in order to decipher it. Now, they had the checks, thousands of checks, and they had time cards, thousands of time cards. And they had a checkbook disbursement journal, as I recall, and there was this great big green ledger book. I looked in that thing, and it had marks all over it. And I'm going to use the word marks. That book was just filled with marks. And they were kind of orderly marks. There was marks that went into columns like this. And the guy said he didn't understand those marks. And I said, well, I don't understand those marks either. Well, then, would you mind sending us the code? Sir, we don't have any code here. I don't know what you mean by code. The court order didn't say anything about delivering a code to you. The court order said that we would deliver and leave in your office. And I read, oh, he just come unglued on that telephone. He called me everything but a white man. That's how mad that guy was. And he was a public bureaucrat. They're not supposed to do that. I could tell he was angry and upset by some of the words that came out. You know, those 4-letter words, you know. And I'll see you in court, blah, 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 you know. They had those records for a year, and they finally sent them back with a little note that says, no additional tax. I could have told them that going in. And I got to talking to the company controller about that, and he said, well, I'm a law-abiding citizen, and I'm a man who believes in the law, and this guy's a lawyer. He's our company controller, and he's a lawyer. He's a lawyer from New York, and he's a Jew. Heck of a nice guy. And he told me that the law required us to keep records. It didn't require us to keep the records in English, and that's what I learned from this man. You can keep them in Sanskrit, you can keep them in Babylonian, you can keep them in German, you can keep them in whatever you want. But if nobody can read them and if nobody can make sense of them, you don't have to go in there and testify against yourself. You don't have to go in there and explain anything. You will deliver the records, and I delivered the records. Now, if you're an individual, you see, you don't need to keep any records. Hale versus Henkel will protect you. You have your Fourth Amendment rights to be protected in your persons, houses, papers, and effects. And that's the law, and that's the rule. How many rules are there? You know all the Supreme Court cases? Do you know your little book there that says legal quotations? Those are all rules. The Supreme Court set down these rules and documents, haven't they? There are these demands, rules and demands. And you've got these rules of civil procedure, and many of these will apply in the criminal process. For instance, voir dire is a civil rule, selecting jurors. And discovery, that's Rule 16. That's a civil rule. You need to use these civil rules in criminal form because the courtroom itself is going to be operating pursuant to the rules of civil and criminal procedure. But the form in a criminal case comes under these criminal rules. Well, all of the Supreme Court decisions are rules. And the statutes will oftentimes be rules. Remember, bail? Remember, money, coin, what is a dollar? That's a statute in the state of Idaho. The court can't effect a remedy by ordering you to pay walrus fat. They've got to order the judgment or the payment of a fine in dollars. Well, what's a dollar? Well, a dollar is 371 1/4 grains of silver, so says the Coinage Act of 1792. Well, I don't have any dollars with which to pay. You see, you're following the rules, following the law, but the law can't affect you because that rule doesn't apply to you. Now, let's take a look at another book. Boy, this is a keen book. This is a real intimidator here. Now that we've covered the funny story of good old Judge Schmidley, and you see how that works and works to your advantage, let's take a look at this book here called The Trial Judge's Manual. It's that black book that you've got. And in the state of Idaho, you're not supposed to have one of these. These aren't in our state law library, and I'm not going to tell you how we got this one. I'm not really sure I know. I just kind of think I know how we got it, and I think we got it legally and lawfully, though I wouldn't suggest by any stretch of the imagination that anybody stole this book or anything like that. But somehow or another, someone got this book, and it's called The Trial Judge's Manual. Now, this isn't law, and I'm going to show you that when we get right up here. I want you to open it up to the very front cover where it says Trial Judge's Manual. And let's read and see what the trial judges know that we don't know. See, I like to know what they know. That makes me smarter than they are, because they don't know what I know, but I know what they know. And so it says here that the Trial Judge's Manual for the state of Idaho was prepared and drafted over a period of approximately 18 months by a professional writing consultant under the supervision of a select committee of trial judges and attorneys appointed by the Idaho Supreme Court for this specific task. The members of the committee and the writing consultants are as follows. And so here's the name of the people that wrote this Trial Judge's Manual. The preparation and publication of this manual was made possible by a matching fund federal grant to the Idaho Supreme Court through the Idaho Law Enforcement Planning Commission. Here's some federal dollars, sounds like to me. The manual is intended as a reference aid for trial judges and is not promulgated. Oh, and what? And it is not promulgated as rule or order of the Idaho Supreme Court. Gee, that's interesting. So whatever this thing is, I don't know. But I know what it is not. See? See what a reading lesson can do? At this point, we don't know what it is, but we know what it isn't. It is not a rule or order of the Idaho Supreme Court. The contents of the manual reflect the opinion of the writing consultant, the advisory committee members, and the project director of the federal grant. So this thing was written to eat up taxpayer dollars. The only function that it serves is to squander money. And it says so right here on the front page. The advisory committee did not consider major sentencing topics, which are covered instead in the Idaho Judge's Sentencing Manual. Okay, we don't have the Idaho Judge's Sentencing Manual. All right, let's just run through then, and let's take a look then at the table of contents, which is the next page over, and it'll tell you then what the subject matter is. Now, I'm not saying that this book isn't of any value, because we've gone through it and we find that it's of some value. But what you need to do when you're reading something is to train your mind now to think in legal terms, because we're used to reading Mad Magazine and we're used to drawing conclusions based upon a phrase or a sentence or a conclusion based upon a paragraph because it leads us to believe something. But in law, the only thing that we believe is exactly what's said. Now, if you were to look at this, you would assume, hey, here's the rules that the judges go by. Hey, look, boy, this is really valuable. Why, this is the way the judges make decisions. No, they don't. And if they do, then it's in violation of your rights, because this book isn't law. It isn't even rule. And let me tell you, the trial judges do use this book, And the trial judges do make the errors that are contained in this book in violation of what is the law, which is the rules of criminal procedure here in the promulgated, which is the official rule. Let me show you the difference. Now remember, a little earlier in this tape, we turned over to Rule 1, didn't we? And no, that was in Rule 2. Now take a look at Rule 2 then. Let me show you this. It says, Rule 2C, it says, no district court or magistrate division of the state shall make rules of procedure except as expressly authorized by these rules. So, it's your Idaho Rules of Criminal Procedure, and expressly authorized by these rules. Now we come over to the trial judge's manual. No lies in here. It says plainly that this trial judge's manual is not a rule or order of the Idaho Supreme Court. The Idaho Rules of Criminal Procedure are, the Idaho trial judge's manual is not. I think that the trial judges in this state go by the trial judge's manual based upon the errors that they make continually. Now, you want to know what the judge is up to. You want to know what he's thinking. You want to know how he's going to perform or what he's going to do before he does it. I kind of liken that, to a guy that's out in the war, and you want to know what your opponent is up to over there. You're the general, and you want to know, are they going to retreat or are they going to attack? If you knew what they were going to do, then you would know what to do in response. If they're going to attack, you might say, well, let's beat them to the punch. Let's attack first. If they're going to attack, you might say, well, let's dig in and let's make some fortifications. If you knew they were going to retreat, then you'd say, well, if they're going to retreat, let's us attack, and we'll get more ground that way. And that's what happens when you read your trial judge's manual. Now, if you're out in Texas or Illinois, why don't you go to work on talking to some people? There are influential people that would like to help you. There will be lawyers in your community who are red-blooded, all-American patriots. Now, let me just run this thought by you. We've got a lot of good lawyers here in our local area. They will not go on the record and they will not go into the courtrooms defending our rights. But they'll certainly tell us what all of the chicanery and the evil and the wickedness that's going on in those areas, like our our prosecuting attorney and some of our law enforcement agencies. They'll tell us what the practices are and tell us and show us and help us with what we need to do. And most businessmen have an attorney or a lawyer. Why don't you feel him out a little bit wherever you are and ask him if he'll help you in this fight? If he's honest and patriotic, he will. But like my friend told me, I wouldn't go into that courtroom and do what you're doing on a bet. I'd be disbarred in a week. And that's right. See, we citizens can go into the courtroom and demand our rights. We citizens can go in there and challenge this procedure of informations and this procedure of depriving us of our grand jurors. But lawyers won't do that because, remember, they belong to the union. And if they were to do that, they'd end up getting disbarred. And so their hands are tied. Remember, rights cannot be demanded by an attorney or a solicitor. That has to be by the belligerent claimant in person, so says your Supreme Court. Now, you'll notice in this table of contents here, let's get some judges' perspective on some subject matter. It says the Idaho court system, small claims department, court facilities, civil procedure before trial, civil trials, criminal procedures prior to trial, juries in criminal cases, traffic offenses. Okay? In other words, this book is designed to tell the judge not the rules of the game, but the procedure that he's to follow when he's in the courtroom. And when the judge does that, then he's doing right and good and he's not violating your rights. When he gets to jumping off the tracks of sanity and instituting rules and procedures that are prejudicial to your rights in violation of the rules of procedure based upon suggestions by the trial judge's manual, you need to be aware of it so that you can call him on it at the time that it occurs. For instance, I was in a trial the other day, and pursuant to our rules here in Idaho, the judge has to swear the bailiff that he will keep the jury. All right? For For the first time in 5 years, I actually saw a judge obey the law, obey the rules. This particular judge, a couple of years ago, he and I had a real knockdown, drag-out fight. We had bad words between us. But I noticed this last time I was in his court, not only has his procedure been radically altered and changed, his personality and his deportment and his attitude toward me personally and those others in our community who are citizens concerned about their rights. I notice that he treats them a whole lot better. Now, judges are just people like all the rest of us, and this is an educational endeavor, program, however you want to word it, whatever adjective you want to hang on it. And judges don't know everything. Judges have to learn just like we do. You know, I thought I had rights when I was a corporation. Judges think that individuals and corporations, as do most lawyers, are synonymous terms, and that there's no differentiation between the two of them. Well, all we need to do then is to remind them that there is a case called Hale versus Hinkle. Now, just mentioning the word Hale versus Hinkle does not educate, because they're not going to just run out and go to the law library this afternoon and read Hale versus Hinkle. But what they will do when you submit paper and you write Hale versus Hinkle, and don't just make the citation, make the quotation as well as the citation. Then he'll read that and say, well, my goodness, did the Supreme Court really say that there's a difference between individuals and corporations? Yeah, there it is, black and white. Then he's faced with this alternative. Either it's a misquotation and this defendant's lying to me, or if it's a true quotation and he's telling me the truth, I've been off base and out to lunch. Another thing that you might keep in mind is this. Never tell a judge or a prosecutor that he's off the wall or out to lunch or that he's making an error. To do that is to call into question his character, his integrity, his education, and everything that he is. And I never like to tell a man, hey, you're a dumbhead. What I like to do is just ask him some questions that he can't answer and suggest that he research it and then show me that I'm wrong. We did this to a prosecutor out in the traffic court one day. He was telling us that the Supreme Court has said that everybody who drives a motor vehicle has to be licensed. Well, I've read some Supreme Court cases, and I think that Crandall versus Nevada and Delaware versus Prouse are a couple of good cases. I think the police power cases dating from an 1882 brewery case in Kansas, I forgot the name of it right now, I think that based upon some of those cases that the Supreme Court would hold a little differently, but I didn't want to sit there and preach a lot of this guy. I mean, after all I am is a dumb businessman. So what I did was this. I said, I'll tell you what I'm going to do, Mr. Prosecutor. If you can produce the Supreme Court case that absolutely tells me that I have to get a driver's license and that I'm out to lunch and off base, I'll have a driver's license for your inspection within 24 hours of the time you short me. And he thought he had an answer. So I said, we'll be back in court here in about a week. Let's see if you can research that, and I'd really be interested in seeing that Supreme Court case. Because if he had such a case that says that the Supreme Court says everybody who drives a car has to have a driver's license, then if I wanted to argue that position, I'd be on the left side of the issue, wouldn't I? And I'd have to go clear back to Washington and hope that maybe they would reverse their position. My position is that they've already said that it's a tax and you can't tax a right, and it's a right to use the road. Well, came back a week later and I said, well, hi, Mr. Jones, how's everything going? Have you got that case? And he said to me, well, no, I don't. Well, did you have a chance to look for it? Well, yeah, I did, but it didn't say what I thought it said. What he meant to say is it didn't say what I wanted it to say. He wanted the case to say you have to get a driver's license. He's assumed all of his life that he has to have a driver's license, and so that's why he has one, and since he has one, he assumes you have to have one. This very same prosecutor, 1 year later, and this has been about a year ago, I was out there in the court with him on February the 28th, 1983, through a jury trial for driver's license registration, proof of insurance. That same prosecutor, a year later, walked into court and said, Mr. Gordon has a driver's license, and he paraded around this proposed spurious document. He'd gotten the wrong name, and he thought that I had a driver's license. And he said, "This is Mr. Gordon's voluntary evidence of consent into a regulated enterprise." Where do you suppose he heard the words voluntary consent into a regulated enterprise? He got that from George Gordon. That's where he got that, from my briefs and motions. Now, the man still believes I should have a driver's license, and he's still, trying to force me to do that, and he's still prosecuting me, and he's still getting guilty verdicts out of juries. But do you see the progress we've made with the man? At least now, he's no longer ignorant about what the Supreme Court says about driver's licenses, is he? He knows that it's voluntary, and he knows it's evidence of consent into a regulated enterprise. And he knows that George Gordon is claiming that he's not involved in a regulated enterprise. That's what that really boils down to.